the Supreme Court recently decided on a judgment on a case which was State of Maharashtra versus Aspi Chinoy. This was a landmark judgment because it gives relief to a large number of landholders, particularly cooperative housing societies which have come up on the lands granted by the collector. These lands have been granted to individuals or private entities. Later on, these individuals or private entities built up these buildings, and then the buildings were converted into cooperative housing societies, and presently the lands are occupied by the cooperative housing societies. So, we have to realize that these are direct land grants to the societies by the government. It has been given to individuals, private entities, and then the societies have come into being. So, this is the difference that is there. Now, Supreme Court has said that these kind of lands do not have to pay any premium to the government for the transfer of flats or transfer of membership. So, let us go into the background and find out what exactly happened. See, land grants have been happening right from a long time, almost 400 years, right from Portuguese time to the British times, and then again when the Maharashtra government came into being, or even Bombay state was there. There was land grants. Land grants earlier, because cooperative society is a new movement, the lands have been granted earlier to individuals. And in Mumbai city, those lands were given on lease basis for a long term tenure. Some of them are as good as 999 years. Most of the lands are 9 years or at least minimum 50 years. They are classified by the Maharashtra government under the law, Maharashtra Land Revenue Code, as class 2 occupants under section 29(3)(c). So, these lands, particularly in Nariman Point, Back Bay, these are the lands that have come up in the sea. The government showed made auctions in the sea and told them to occupy those lands. All the bharni, what you call the land filling, was done by the people who purchased these auctions, who purchased these lands in auctions, and then the infrastructure was built by them, and such lands were basically given at auction rate. You can understand they are market rate land grants. The land grants were given to individuals, private entities or companies, and later on they built residential premises, and once the residential premises were built, the societies where the land was transferred to the society. In some cases, the land transfers are yet to take place, but under MOFA Act, they are deemed to be granted to the transfer to the societies. So, what happened is the land grants were done up till 70s. The government never bothered about transfer of membership. In 2000, suddenly they woke up that these lands should pay some money. They wanted to make revenue or something. There are certain notes that are there where they said internal notes that have been put up by collectors to the government saying that now we should make revenue from this and so on. And that is where the problem started. One of the collectors in Mumbai suburbs, he gave an advertisement in newspapers. He circulated notes to various societies that you are now required to get the approval for the memberships, and you should approve the same and all that. So, this was in somewhere in 2000 or so. In one such case, in one such place, one Mr. Aspi Chinoy, who is an advocate in High Court, Supreme Court, he purchased a land in Back Bay. He purchased a flat in Back Bay area. I will not name the society and all that. Now, the flat was purchased. The government said you cannot register the document unless you make the premium. You pay the premium to the government. So, Aspi Chinoy went to Bombay High Court and said we are not required to pay the premium, and there are 2-3 things he put up across the court, which the court accepted. So, what are the things that he put up and what was the acceptance of the court? he said that under the Cooperative Act and the clauses that are there in the agreement, the person who is purchasing the flat is not required to pay the premium. What are the clauses of the agreement? So the land was granted to a private company, it came to the society, then the flats were in the name of individuals. So in the agreement it is stated with the government that you sell a part of land or part of premises by the landholder, then it is subject to a premium transfer of premium. That is one argument that was put up by the government. The second argument, the High Court rejected this argument, saying that the society is not transferring any part of the land, or the premises. The land or the premises are in the possession of the society, and that it is only a transfer of membership, and the flat is, because of the transfer of membership, the flat is given to the member. Now that is one aspect of it. Then the second aspect the High Court dealt was, it was dealt with one of the judgments called Anita Enterprises and others versus Belfast Cooperative Housing Society, wherein it says, although de jure he, a member, is not the owner of the flat allotted to him, but in fact he enjoys almost all the rights which an owner enjoys, which includes the right to transfer. So this is a very basic principle of a cooperative society, where a member does not have to go to the government, or he is as good as the owner, and he does not have to go to any party to take acceptance for the transfer and all that. So this is the first argument that the High Court accepted. The second argument put up by the government was that these cooperative societies are subject to a GR dated somewhere in 83, and in 99 there are two GRs that are there. Now both these GRs are applicable to the cooperative societies. So the High Court went into the GRs and found out that these GRs are basically designed for giving powers to the government to give land grants to cooperative societies. They come from disposal of Land Revenue Rules 1971, which gives powers to the government to dispose of lands to the cooperative societies, directly to the cooperative housing societies, and that too under concessional basis. So the court said that this GR is applicable, the rules of this GR is applicable only to those lands where the land grant is done directly to the cooperative housing society, and they will be these rules will be applicable to them. And in this case, the case of Aspi chinoy and the land society, the landholder society, this GR is not applicable because it is not directly granted to the cooperative society, but to an individual or a company. So these are the two arguments put up in the Bombay High Court. Now against this judgment, the state government went to Supreme Court. Now this judgment of Bombay High Court came in 2009. So from 2001 to 2009, 8 years passed. Then the Maharashtra government went into Supreme Court, and the final judgment came only about a month back or so, in 22. So about 21 years have elapsed for this judgment to come. Anyway, so what did the Supreme Court say? Supreme Court held the same thing, held up the High Court verdict. It said that any individual or a private landholder who has been granted land by the government, and then the society has come, the rules of 1983 and 1999 are not applicable. The government rules are not applicable. Therefore, the question of paying premium does not arise at all. So this is one of the major relief to the cooperative housing societies. But there is one more thing that I want to bring out, and that is the problem with the government is that As part of the Supreme Court judgment, the government, the collector or their various government officials, they will keep insisting that judgment is applicable only to them and not to you, and many societies get affected by this kind of attitude by the government. I will give you one example. Somewhere about 4 or 5 years back, there was a judgment by Bombay High Court again, where there are two parties which went to Bombay High Court. One was BACS and there was another person, Pankaj Pandya. Both of them had gone to the High Court saying that this kind of premium is not applicable to them because of the High Court Aspi Chinoy judgment. So, this case went off for 2-3 years or something like that, and the High Court asked the government whether there is a stay on Aspi Chinoy Bombay High Court judgment. The government dilly-dallied for a long time. Ultimately, it said there is no stay from the Supreme Court on Aspi Chinoy judgment. So, the question asked was whether there is a stay from Supreme Court on Aspi Chinoy judgment. The government said no. So, it said that the Aspi Chinoy judgment is not stayed, and these cases are similar to what Aspi Chinoy's cases are. Therefore, all the judgment is applicable to these lands also, and therefore, the transfers that have taken place on these lands are also not chargeable to any premium, transfer premium and all that. So, it has given relief to similar lands in earlier case also. So, government has to realize that they have to come out with a GR, clarify down the line collectors and other people that such kind of lands are not, the government cannot charge premiums, transfer premiums for transfer of membership. One more question that comes, whether there is any relief that other cooperative societies can have because of this judgment. Actually, land grants before 1971 have been done by the government even directly to the cooperative housing societies on market rates. Then they started the concept of concessional rates. The question that comes is, if the government has given land grants on market rates, whether this judgment is applicable. Because the wording is very clear that it is not applicable to cooperative housing societies. That is, the Supreme Court has made it very clear that the transfer premiums are not applicable to individual and private entities who have been granted lands, but applicable to the cooperative housing societies. All the cooperative societies which have been granted lands directly by the government, and there is a conveyance between the government and the order directly in the name of society, there this judgment is not applicable. Now, let me put it this way, whether this judgment would have been applicable if we had gone to courts earlier. I would say that the Aspi Chinoy Bombay High Court judgment, let me put it this way, whether this judgment would have been applicable if we had gone to courts earlier. I would say that the Aspi Chinoy Bombay High Court judgment, and particularly Anita Enterprises and others versus Belfast CHS, wherein it says that the owner enjoys, owner is the flat holder, though he is called a tenant, enjoys all the rights of a owner, which includes right to transfer. Now, if some society or some people, some association had gone into the High Court 10 years, 15 years back on the basis of this judgment, then we could have got relief from the government's harassment of transfer of membership. Unfortunately, for cooperative housing societies, going to the courts is almost a no-no. They don't avoid going to the courts. But if they had gone there and on the basis of this judgment, or Dr. Bharadwaj judgment, or on the basis of Dinanath judgment, they could have come out with a much which gives our cases also very strong. But we have not gone to the courts and got relief from that. If we had done that, maybe we could have also got the relief in this case. but this judgment is not helpful to us in any case, to the cooperative housing society which have been granted lands directly by the government. Thank you.